Hello, everyone. My name is Lauren Antone, and I'm the Senior Marketing and Events Coordinator at MAR, as well as the producer of our free webinar series. Our webinar today is All Housing is Local, Opportunities in the Housing Choice Law. This webinar will cover the state's new housing choice law and the collective work of implementation in our cities and towns. After our live session, the webinar will be recorded and added to our website at marealtor.com under webinars. If you have any questions throughout this session, please type them in the bottom of your chat box on your screen and we'll hold a Q&A afterward. Our presenters today are Catherine Rollins and Chris Kluchman. Catherine Rollins is MAR's local policy manager. She works with local associations and members on strategies to develop strong public policy for housing and property rights in our cities and towns. Now, over to Catherine.
Thank you very much, Lauren, and thank you to all of our members for joining us on what is very much a beautiful summer day. We appreciate you taking the time to learn about some opportunities that are present in a new law, the Housing Choice Law, which was enacted this past January. Now, to get right into why we're here. This is the bottom line up front. I thought it would be helpful just to share some very basic, straightforward content with you. I don't need to tell any of you that certainly in Massachusetts, we need more housing of all kinds and all varieties. You see this every day in your business. You see the inventory shortage and the prospective home buyers who can't find anything suitable or anything that is within their budget. You know what this does to a community and how it limits growth. Zoning, as you know, is what determines what housing can and can't be built in a community. It's not a glamorous topic, but it's an important one. So I'm very pleased again that you joined us to discuss some of it. Zoning is decided locally, but it is based on state law. There's statutory authorization for local zoning. It's different in each of our 351 cities and towns. Again, I believe all of you probably practice in multiple communities, and you've seen that the rules are a little bit different in each and every community. A good thing, in my perspective, is that regardless of the city or town, zoning can be changed. And this is where you can come in and why we wanted to talk to you about this new law today. Zoning is something that can be technical in nature, but we don't need you to be zoning experts to help get the ball rolling locally. We think you're very well positioned to start having conversations about housing and zoning in your communities because you know your communities, you know the community in which you're a resident, you know the communities in which you do businesses, you know what people are saying, what their concerns are, what their needs are. And you have, dare I say, the right personality to do this. You know how to negotiate, you know how to be diplomatic, and you have great existing networks. So I'm always happy when I can try and, remind you of the role that you yourself can play and how you can really help promote housing where you live and work. So again, one of MAR's top legislative priorities in recent years has been something called the Housing Choice Bill. It became law again earlier this year in January, and it paves the way to change zoning locally. So with that, it is my pleasure to introduce our guest speaker today. Chris Kluchman is the Deputy Director, Community Services Division, Massachusetts Department of Housing and Community Development. And she, in this role, oversees and coordinates programs in the division, including land use, economic development, and technical assistance functions. She manages several programs, including the Housing Choice Initiative, grants for rural communities, and in support of local planning. Prior to her work for the Commonwealth, she worked for the town of Westford for 7 years as the Director of Land Use Management and Town Planner. In 2016, Chris was recognized for outstanding contributions to the field of planning as a fellow of the American Institute of Certified Planners. She worked in Oregon for the first half of her career, including co-founding a planning firm. She and her family live in Acton, Massachusetts. So with that, Chris, welcome, and I will turn it over to you.
Thank you so much, Catherine. It's really a pleasure to be here, and I hope this presentation is helpful to you to understand this new law. Let's just go right into the next slide. So as Catherine said, this has been something that the Baker-Polito administration has been working on for several years with the support of the Massachusetts Association of Realtors, as well as many other advocates, both for housing and for economic development. We had businesses that were saying that they're having trouble recruiting people into Massachusetts. So that's not only a housing problem, it's an economic development problem. So, and we understand that not all cities and towns are the same, and we wanted just to make it easier to change zoning to increase housing in Massachusetts. So you can see with this timeline, in January of 2021, the Economic Development Bond Bill included this legislation, and we're so happy to have it passed. And let's go to the next slide. So as I mentioned, it was an expansive campaign. We went around the state. We, in the John Chesto and the Boston Globe, called it the Housing Palooza Tour. And again, we had lots of support all over from many different kinds of advocates, including MAR. Next. And Catherine talked about this a little bit, and you guys see this on the ground every day, but just to bring some numbers to it, the housing production in Massachusetts has severely changed over the last generation. So between 1960 and 1990, we produced about 900,000 housing units. And this chart on this page shows single family in yellow and multifamily in dark blue. And you can see that in that time period, really a lot of multifamily had been constructed. And then between 1990 and current 2019, I think this chart goes to, there's been a severe slowdown in housing production. And really, we've built only about half of the units in the last 30 years that were built in the 30 years before that. And you guys know this, again, on the ground, you know how hard it is for your clients to find properties. Rents have also risen very dramatically, and Massachusetts, unfortunately, is among the leaders in the country as the highest housing costs. And we like to be number one, but we don't like to be number one in housing costs. And we know that municipalities are a key player in zoning, and because each of them have the authorization to create their own zoning, and the zoning statute that Catherine mentioned, Chapter 40A, has really not been substantially modified in the last 25 years, and it was time for some updating. Next slide. So the basic change, and just a really quick overview of the legislation that was passed, is it changed Chapter 40A to make the threshold for votes for certain zoning amendments that have to do with promoting more housing, instead of needing the supermajority of a 2/3 vote of either a city council, a town council, or a town meeting, that these certain zoning amendments will only need a simple majority. This applies to every city and town in Massachusetts except for Boston. Boston has its own statute and is not covered by this legislation. But there is nothing that towns need to do. It simply changed the law. There's no opt-in. It applies now across 350 cities and towns in Massachusetts. And so the kind of best practices that receive that reduced simple majority voting threshold include, increasing density, adopting a 40R smart growth zoning, or adding accessory dwelling units. And I'm going to get into some more detail about that in the next couple slides. Let's go to the next. I do want to take a moment to say that there are a couple other provisions in the bill that are just good. They're not directly related to zoning amendments. One is revenue sharing agreements. If there is a project that's on the edge of one community, but another community bears a lot of the effect, such as all the traffic has to go through one community to get to another site, we can now allow those communities to agree to share revenues. That used to take a home rule petition, which meant the legislature had to act on it. And so that's been simplified. There's also a provision, as you know, sometimes housing projects or zoning amendments are appealed by abutters who aren't happy with a change. And those appeals can be called frivolous appeals sometimes. And so there's now a provision that a court can increase the bonding amount that is necessary if somebody's going to appeal. It doesn't say that the court has to increase the bond, but it is seen as something that may help to defray or have those appeals be less successful. And then finally, there's a new provision that the legislature added called generally referred to as the MBTA communities section. And I will be talking about this more in detail, but it does require everybody, 175 communities that are called MBTA communities, to have multifamily zoning by right, at least one district. And let's go to the next, Catherine. So I'm just going to dive right in. And I should say that this presentation is going to be available to you. And so, you know, there's a lot of text on them. And I'm sorry, as Catherine said, zoning is not the sexiest topic. And so there's a lot, but there's a lot of detail. And I want to make sure that you have the detail. So first of all, we're going to talk about the kinds of amendments that qualify for the simple majority. And so this page lists those. If you're allowing for certain housing developments as of right, that means that there's not going to be a special permit required or any kind of discretionary approval. So when a community wants to add multifamily or mixed use zoning in an eligible location, if they're permitting accessory dwelling units, or if they're changing their zoning to allow for open space and residential development without a special permit, those all get a simple majority vote. And then there's if you have certain things that are allowed by special permit, multifamily and mixed use, again, in an eligible location, detached accessory dwelling units, which are often done by a special permit, increasing the number of units on a property, which you can do with a special permit, but if you're changing your zoning to allow for that, that gets a simple majority vote. Or if you're reducing parking requirements, those are all simple majority qualifying amendments. Next slide. So I think you can all, if you've been to town meeting or to a city council meeting, you understand that, you know, to get that 2/3 vote really can be difficult. And so we feel that these changes will allow these amendments to be made easier. Other qualifying amendments, including if you're increasing density, as I mentioned, so that is, you know, you're reducing the lot area, increasing height standards, reducing setbacks, reducing parking, reducing the required open space. Those are all things that add additional units. If you're adopting a Chapter 40R district, which are known as smart growth districts or starter home districts, that's a simple majority. If you're adopting natural resource protection zoning or transfer of development rights. TDR, which is transfer of development rights, is not very popular in Massachusetts, but it is a tool in the toolbox that can be used to increase housing in certain areas while protecting open space. Next slide. Thank you. So I have some examples just to you know, bring this home. So that let's say that a municipality wanted to allow for owner-occupied accessory dwelling units up to 800 square feet. And you could do that with just a building permit. That is, it's as of right. And so that meets the simple majority because it meets the definition of accessory dwelling unit and would, you know, that kind of zoning amendment would be simple majority. There is a definition of accessory dwelling units in the statute that is 900 square feet. And so allowing for larger accessory dwelling units would not qualify for a simple majority vote. And this is just some of the details that are part of the legislation. Another example is if a community wanted to change 1 acre zoning to half-acre zoning, even if it's just for single family homes, that's, you know, increasing the density by 2. So that would qualify. If you're in a more urban area and you're reducing a lot size or minimum lot size from 10,000 square feet to 5,000 square feet, again, you're basically doubling the density. That would be a simple majority vote. If you wanted to allow for a 40R district, that allows multifamily residential units near a commuter rail station, that city would only, instead of needing 8 of 11 votes, you would only need 6 of 11 votes. So again, you know, with the politics of zoning, those 2 votes really can make a difference to make something easier to pass. Next. And to give another example of, you know, maybe a more rural community or a smaller town, if you wanted to increase the density to allow for duplexes in an area in, you know, where seniors could live, and that's a need in that community. And let's say that you have a very small town meeting. And I'm just kind of giving this example to show that it's not, super crazy. You still need to have a majority of votes, but instead of requiring 41 votes, you'd only need 31 votes. So again, just can be easier at town meeting to get those done. There are lots of zoning amendments that will not qualify for simple majority because they're not related to housing and housing production. So zoning that changes limited business to heavy industrial, or zoning that decreases density, those would still require the 2/3 votes. There is a provision in the law that talks about, that goes into the vote of a board. And so mostly what I've been talking about is zoning amendments. And so those are at town meeting or city council. Special permit boards also require that supermajority vote. But in certain circumstances, that supermajority special permit board can use a simple majority vote instead of the supermajority. And that would be when you're reducing parking spaces with a special permit, or if the zoning already allows for multifamily or mixed use in an area of concentrated development or near transit, and a project comes in for approval, and that approval requires a special permit, and the project includes at least 10% of the units as affordable, that approval of that project would only require a simple majority of the board. And Catherine, if you go to the next slide, I have an example, because that's kind of complicated just to talk about in the abstract. So here we have a community that already allows for multifamily projects to be approved by a special permit in its town center, which is adjacent to a commuter rail station. And that special permit, any project that would come in under that would require a vote of its planning board, which is a 5-member board. And let's say they had a project that came in from a developer and was close to the commuter rail station. It was a 100-unit building with over 10% of the units as affordable. And instead of needing 4 out of 5 votes, it would only need 3 votes from that planning board. I do think that this is an important change for these kind of, that will allow these kind of projects to be approved, not only with not needing that, almost unanimous vote, but if you've been involved in special permit hearings, you know that sometimes it can be just difficult to have the same number of planning board members attend all of the meetings and be eligible to vote. And so just needing 3 out of 5 votes can be helpful in terms of time frame to allow projects to get through the permit process faster. Next slide. There is a provision that changes the protest votes. This only applies in cities and towns with town councils. So it really doesn't apply to most communities in Massachusetts. Essentially, it used to be fairly easy to protest in a zoning amendment by a city council. Especially, so you needed only 20% of the abutters or landowners, and then that would require the vote to be reaffirmed by that board or by the city council with a 3/4 supermajority, a 75% majority. And that's been changed now to make it a little bit more difficult to protest. You need more landowners to sign on. And then to affirm the vote, the city council or town council would only need to affirm it with a 2/3 majority instead of the 3/4 majority. This is a little bit of a esoteric detail. It doesn't happen that often, but it would be now more difficult to protest those votes. Next slide. So we now have created a system in Massachusetts where at the legislative body, whether that's city council or a town meeting, we've created 2 different kinds of voting thresholds. One's at 2/3 and one's at simple majority. But the law doesn't actually say who makes that decision, the Chapter 40A law. And ultimately, that is really a coordination between town councils and the town moderator. But what we are recommending is that as communities are going through zoning amendments that they believe qualify for simple majority, that they should be, at every step of the zoning amendment process, you should be having a discussion about, does it qualify for simple majority and why? So if a petitioner is bringing a zoning amendment, or if the planning board is generating zoning amendments, they should be explicit in whether it qualifies or not. Again, we recommend that communities are talking to their town councils to be clear that they agree with the determination that something meets the criteria to qualify for simple majority, and that during those public hearings and when the planning board has to give its report to the legislative body, that it be clear about why the proposal meets the simple majority threshold, and that way everybody's kind of on the same page about how this would proceed. And so when people are voting on it, they understand that it's simple majority and why it's simple majority. For towns, this does not apply for cities, but for towns, the Attorney General's office does have to review and approve zoning amendments after town meeting is finished. And so we are in a period where the Attorney General's office is beginning to start to issue those decisions based on some of the spring town meetings that have used the simple majority process. We are in a period right now where there's not a lot of, we don't have a lot of precedent on this issue, but as things evolve and the Attorney General's office starts issuing those approvals or commentary on simple majority votes, everybody will have more information and things, I think, will be a little bit more clear. Next slide. So the MBTA community section is a new section 3A of chapter 40A, and it provides that if you're an MBTA community, you have to have at least one zoning district of reasonable size where multifamily housing at 15 dwelling units an acre is permitted by right. That is not through special permit, but permitted by right. It's my opinion that site plan review is a by right process. And so communities that have site plan review could potentially use that. But we are looking at this zoning, the multifamily district, to be near a transit station if it exists in a community. And if it doesn't exist in a community, you still do have to have the 175 communities that qualify here still have to have the multifamily zoning district. But obviously, if you don't have a transit station, you can't put it next to it. And then the provisions in this district also, and this is in the legislation, cannot be age restricted. That is, it can't be just senior housing, and it must be suitable for families with children. So these are a fairly complicated set of provisions that are broad policy statements in the legislation. And the statute does require my agency to issue guidelines to help communities understand how you would comply with this requirement. I say requirement, and let me be more clear about that. It's not a requirement. The way the legislation was written is that if a community does not comply with this requirement, it will not be eligible for certain capital grant programs. So a community can choose not to do this, but it would mean that you would not be eligible for the MassWorks program, and you would not be eligible for housing choice grants, nor grants under local projects, local capital projects. So we issued guidance back in January, so pretty soon, right after the legislation was adopted, to be clear that until guidance is promulgated, that all communities are in compliance. So communities have been able to apply for MassWorks and housing choice grants in the current grant round, which is now closed, but was open through the beginning of June. We have been working on guidance. If you can go to the next slide. We do think that this is a very important part of the legislation, and we plan to issue draft guidance and receive public comments on that draft guidance, and then issue a final guidance later this summer. The information here on this slide, mass.gov/housing choice, will get you to guidance that has been issued to date. That is formal, and it is very useful information for towns, for if you're a property owner and you want to understand how the threshold of vote works, and when the draft guidance for the MBTA communities is available. It will be posted there. If you have questions, you can send an email to housingchoice@mass.gov. We may or may not be able to answer every single individual question from folks, because as you might imagine, there are many questions that people have, whether you're a town council or a planning director or a property owner. So we are trying our best to reply to, either reply individually or to take questions that we get in that email and provide answers to those questions through guidance. And the guidance right now is really taking the form of frequently asked questions. And we have issued a series of guidance around the voting thresholds, and we've been updating that. And so if you check once, I would advise you to continue to check back, because we will, again, as I said, the MBTA communities guidance will be posted there, as well as continuously updating the threshold of vote guidance. And Catherine, I think that's the end, and I'll turn it over to you.
Great. Thank you so much, Chris. That is a lot of information and super, super helpful. The one thing that is clear to me from Chris's presentation, and I hope is clear to everyone, is that there's a lot of opportunity inherent in this law. You could certainly say the door is open, but nobody is pulling you through the door. No one is pushing you through the door. So if a local government, through its legislative process, whether that's town meeting or whether that's a city council and a mayor, if no one takes action on any of these items within the law, nothing changes at the local level. So it's not a law that can preempt whatever local zoning is. It doesn't do anything automatically. It just gives you the opportunity to do something supportive of housing in your community. So that's really important, I think, for everybody to understand. Everything has to happen now at the local level. We did at MAR do a bit of a guidebook for you, our members, on the nuts and bolts of the issues in this law. Again, zoning can be technical, it can be complex, and we don't expect you to become experts in zoning because you want to help in your community to create more housing opportunities. So we put this on our website, marealtor.com. If you hover over the legal and advocacy section, you will see this document pop up. And really, it just goes through and it tries to explain in plain terms really what these things are and why they might be good in any given community. So I would encourage you to take a look at that if you haven't already. If you can't find it, I'm happy to send it to you as well. And just really to give you a little bit of a highlight from the guide. Really, we do this for each of the issues, but I figured in the interest of your time, I'd really just pick one as an example. This is the type of content we put into that guide. Accessory dwelling units is probably my favorite topic from this law. You probably shouldn't have a favorite, but I do, just because I think there's a lot of potential here, and I think this could do some good in many different types of communities. But as Chris said, basically an ADU, it goes by many names. It can be called an in-law apartment, it can be called a granny flat, it can be a carriage house, a guest house, you name it. There's several dozen different ways to refer to ADUs that I've seen. But again, it's just a smaller home sharing the same property lot as a larger primary home. They can be in an existing space in the basement, attic, or garage. They can be the detached guest cottage or carriage house. And really, here's just a visual representation of 6 different forms. This graphic was done by the AARP. They've done a lot of great work on this because they think it can certainly be of benefit to their members and either helping them stay in their home with either a place for a family member or caretaker to live, or as a source of rental income. Alternatively, you could also picture an elderly homeowner perhaps moving into the ADU and renting out the larger home, which would allow them to age in place. So anyway, the AARP has produced this graphic. This is probably my favorite I've seen, just in making it clear all the different forms that ADUs can take. Why might a community be interested in ADUs or a property owner? They're small, they're limited in size, and that makes them naturally more affordable than average in many communities. They can be a good option to house the local workforce in the same community. I'm sure you've heard a lot of discussion about how, entry-level teachers, waiters and waitresses, postal employees, medical staff, any number of folks who really do need to live fairly close to where they work, oftentimes in many communities just can't afford to access the housing type that's prevalent in that community. ADUs present a reasonable opportunity for those folks who are really important to the functioning of so many of our communities. They enhance variety of housing in a community, and there's no required development of new land or new infrastructure, which is huge. And again, they can enhance the value of the primary property and provide rental income. So again, this is really just a snapshot of the type of information we put in our housing opportunity guide. I would encourage you, if you are interested in any of this, to reach out to me. If you aren't sure whether your community already allows things like ADUs and you'd like to know, I'm happy to do that research for you. If you are interested in any of the provisions in the housing choice law, but you're not really sure who to approach in your city or town government, I'm happy to have that conversation with you. So you can see my contact information there. The one piece I would actually like to highlight, because I just started using it, is at the bottom, calendly.com/RollinsMAR. If you want to schedule just a quick meeting with me or a quick phone call, you can do that in one step just by going to that link. It is synced with my calendar. There won't be any back and forth on what time works for you, what time works for me. It'll just show up on my calendar. And I would love for folks to feel free to use that anytime if they do want to talk about the options presented by this law or really any other local issue that impacts real estate. So with that, Lauren, I think we are happy to take any questions.
Yeah, absolutely. Well, first, thank you so much for this great presentation. And if you have any questions, now's the time to write them in your chat box. It looks like we don't have any questions at this time, but maybe if we give it a couple more minutes for everyone.
Sure, and I do have a couple for Chris, just in case we did have time, a few things I'm curious about, or I think our members might be curious about. Chris, you mentioned the Housing Choice Grant Program, and it's similarly named. Can you just tell us a little bit about what that is and what, if any, relationship it has to the law?
Sure, thanks, Catherine. That's a great question. I've been running the Housing Choice Initiative, which was something that was formed by the Baker-Polito administration back in 2017. And it is part of the legislation was one leg of that stool. And so the initiative also includes a process to designate communities that are producing housing. And so there's a process to do that. If they've been producing over 5%, an increase of 5% of net new housing units over the last 5 years, that's the qualifying feature. Or if they have a bunch of zoning best practices, they can also qualify. Once a community is designated, I run an exclusive grant program just for those communities. That is a capital grant program up to $250,000. And so I've given out over $15 million in the last 3 years to communities across the state and this is rewarding communities that are building housing so that to do things like improve infrastructure or redevelop a park or whatever it is that they have a capital need for, probably related to the fact that they are now housing more people. And so we want to encourage, it's an encouragement based program. And so that the legislation was one piece of what I've been working on the last 3 years, but the other part is this designation and grant program. Does that make sense?
It does. How many communities participate in that?
Well, communities do have to redesignate every 2 years because we want to see them continue. We now have 78 communities that are housing choice communities. And if you go to that website, mass.gov/housing choice, you have to kind of work your way around the website a little bit, but I do have a map that shows all of the communities that are housing choice communities and all of the grants that we have given. There's a kind of a hatching if they've gotten a grant, and you can read a little bit about each one of the grants that have been given. So that'll give you an idea if the community that you're working in is eligible for that grant program. And so you can connect with the planning department or the town manager to understand if they're interested or want to pursue a capital grant if they are a housing choice community. There also may be some communities that could qualify but just are not aware, and so I'm always happy for people to introduce a community to the idea that there is a designation out there, and obviously that housing choice at mass.gov email. If anybody has a question about the designation or grant program, they can also ask at that email as well.
Fantastic, thank you. The other thing I was wondering, could you just explain a little bit more about what smart growth districts are and maybe sort of what starter home districts are? I know that they have some similarities, but they're not the same thing. One is newer than the other, but just to try and give our members a little bit more framing around what that opportunity is.
Sure, and so this is under another state statute. So we've been talking about Chapter 40A, which is the zoning statute, and that's what was changed with the housing choice legislation. There's another chapter, Chapter 40R, because we like all the 40s, I guess, and it is the legislation that was passed over 10 years ago now, that provided for if a community wants to. Again, it's not a mandatory program, but it is available if a community wants to adopt an overlay district that has certain provisions and meets certain standards that are set out in the legislation and guidelines, but it's supposed to encourage higher density housing with some affordability near transit. And so we like to, we feel that when we're increasing density in particular, we'd like to see that near transit or transit lines that exist. So the 40R smart growth districts. Smart growth is a catch-all for doing development in the right place, I guess I could say. Again, that means near transit to provide opportunities for people to be able to not have to get into their car to do everything, for example, to commute. So it is allows, if you do, it does provide for 20 units an acre, again, near transit. But the legislation is pretty interesting. It has some financial incentives for the communities. If you establish a 40R district, it does have to be approved by my agency, DHCD. So it's a fairly formal application process. But if it's approved by the state and approved at the local level, so it is a zoning amendment, and so it's one of the qualifying amendments for simple majority. The community qualifies for something called zoning incentive payments, just for passing the zoning. And there's a very specific formula based on how much density you're adding, but it can be over $100,000, so it's not nothing. And so there's payment if you create a district, and then if a developer comes and builds that multifamily housing or mixed-use housing at 20 units an acre, there's an additional payment. So it's again, an incentive-based program that pays communities to increase density near transit. Starter homes is in the same chapter and was added relatively recently, I think about 5 years ago, and it is provides for 8 units an acre. So it is a district that could allow for single family housing or townhouse development, does not have to be as dense, and it does have more flexible locational features and requirements. So it is a little bit easier to qualify a site for, and it's at a lower density.
Great, thank you. That's super helpful. I think the last question from me, at least, you're in an interesting role, having served at the town level, working on land use management and planning. I'm wondering if you could just speak to a little bit about how important resident input is to town planning and development processes. What is the role that a resident's input can have on sort of the direction that the community takes when it comes to planning and zoning and land use?
Well, what a good question. So, you know, especially in towns with town meeting, in Massachusetts, residents have a very strong voice. They have a direct voice, possibly, if you participate in town meeting, about how the community is framing what's going to happen. Zoning is one of those quite technical things, as you've mentioned, but also very important frameworks for the community. So, you know, number one, I would say become an informed and educated town meeting attendee. If you live in a community where you have representative town meeting or a city council or a town council, being an advocate for housing is very important. One of the things that we know from some studies that actually a Boston University professor has done, Dr. Katie Einstein, has shown that people who show up and testify at public meetings, only 14% of them actually support new housing. So there is an uphill battle to convince communities that that new housing can be a positive impact. We talked at the beginning of the presentation about the effect that the low level of housing production has had on prices. And so part of that has been local objection to new housing. And so it is important to show up to tell leaders, whether it's a city council or a planning board, that you support new housing. And so that, you know, just going to a planning board meeting and saying, you know, I am in support of this new housing for XYZ reasons. You know, I want my children to be able to live here. I want my parents to be able to move in. And right now, neither of them can afford that. Or I want to be able to age in place, but I don't want my single family house. I want a townhouse, but we don't allow townhouses in my community. And so I'd like to see that. So those are the kinds of things that folks can, you know, just at a very low entry level, you can participate in and try and influence what goes on. If you want to be even more involved, and I would say particularly to this audience, realtors are a very valuable contribution to policy committees. So many towns and cities will have an affordable housing committee, or maybe there's a master plan or a housing production plan that's going on, and you have an opportunity to volunteer on a task force or a committee to continue to promote you know, good planning and thinking about, well, if we want to do multifamily, where should it be? And just thinking about these things and helping to influence the decision makers at the local level. But all elected officials need to know that there are people that support something. I think it's easy when you object to something, you show up to a meeting and you object, but we are not really getting people to show up and say, hey, I support this. And so I think that that's an important role that that your members can play.
Great, thank you very much for that. Lauren, do we have any additional questions?
We don't at this time.
Great, well, I'd like to again thank Chris for joining us today for that fantastically informative presentation, and to all of you, our members. Again, if you're interested, if you have any questions about what this might look like in your community and how we might be able to help you start that conversation, please feel free to reach out. And with that, thanks everybody and have a great day.
Yeah, and just one quick reminder, this webinar has been recorded and it will be available to view in the next few days on our website at marealtor.com. You'll find it under webinars, and you can find any upcoming webinars on that page as well. So thank you again, Catherine and Chris, for your presentation, and thank you for everyone for joining today. We hope to see you next time.